we've had a great lineup of speakers all day. So we're going to do a panel now with two mediators that I've mediated with extensively, Sheryl O'Briant and Joe Jaworski. Y'all come over here with me. So Joe, former mayor of Galveston. Joe's probably done, would you say, over 1,000 Texas windstorm mediations?
I think during Ike, absolutely.
During Ike and ever since then.
Sure.
And then you heard from Sheryl earlier today. She was on the defense side. She represented big insurance companies. I mediated a lot of cases with her. I think we booked one earlier today while you were talking that we're going to be mediating in a couple of weeks. So she has a lot of insight on what it takes to get the claim paid. The conversations that we're not privy to on this side, because Joe and Sheryl are both in the other room taking all of our points back to the insurance company and saying this is why you should pay the claim and this is why I think there's risk out there if you do not get it paid and resolved now. So I have a couple questions that I can kind of gear things towards, but if people can line up at the microphone here, because I would like this is your chance to ask questions of what do they hear in the other room from the insurance company? What's the key points they see to get the claims paid? So if y'all have any questions, please ask them. But Sheryl and Joe, can you tell us kind of one thing that I'm always interested in when I go to mediated cases, who's the decision maker in the other room? People would assume a lot of times it's defense counsel, but more often than not, it's not, right? It's the adjuster. Sometimes it's a litigation adjuster. Sometimes it's the adjuster that was on the original file.
That's right.
Can you speak to identifying that and kind of knowing who to work with on the other side?
Well, I know, Joe, you did a lot of all-state mediations, and Gary Johnson was a decision maker.
Absolutely.
I mediated a couple of cases with Gary and Jay Simon, who now is over at the Chad Wilson firm.
That's correct.
And Jay was kind of like, on his phone looking at Facebook, and because that was his role, right?
Exactly.
If a legal question came up, Jay would answer it, but Gary was running the show. So I tried to figure out immediately who's driving the train for the insurance company. There's a couple that I can tell you. I've had two partners from a big defense firm, offices all over the state, and they just sit there, and the insurance guy, we always have to be careful what we call them. Are they adjusters? Are they litigation managers? I usually call them litigation managers just to kind of, blow their skirt up a little bit, but and the lawyers literally won't say anything. On the other hand, we have lawyers who are absolutely driving the train and even make decisions about what the moves are.
That's right. If I can say this, having done personal injury mediations, workers' comp mediations, first-party mediations, and there's so many others, the first-party claims lend themselves to the expertise of the adjuster, the manager, the PA. Sure, there's legal issues, but those are usually hashed out, and you don't walk into a mediation, where it's high stakes on the law. There may be a motion pending, but no one walks in and goes, pay me my bad faith right now. That's like asking for punitive damages in a truck accident at a mediation. No one will ever pay it. But Gary Johnson, great example. He literally has a formula. This adjuster is very proud of it. He's now on the plaintiff's side,
right.
more than not.
Right.
But I use Gary quite often as an expert.
Well, yeah, and it's just a perfect example. He's a utility man. The guy can swing, and because his knowledge is that deep, like many of yours. So what I would say is, my experience is certainly in first party, it is always the adjuster, or as you say, claims manager. Every now and then you'll have, David Salyer attend, or, Jay Old, someone who's more of a senior attorney, and their job is to speak.
Yeah. When I mediate for travelers, and I do a lot of travelers cases, Bob Shine, who happens to be a friend of mine for 100 years, because he had the bad fortune of trying the Melinda Ballard case while I was just advising farmers. There's always two guys in there on travelers. There's their in-house lawyer. I can't remember his name as I sit here right now. Andrew. Andrew's in there as the in-house lawyer. So you got the out-house lawyer, Bob, the in-house lawyer, Andrew, and then you have the litigation adjuster. who's very seasoned, been adjusting cases for many, many years. He's the money guy. So it's not just who's driving the train, it's who's driving the money. And every once in a while in the insurance room, I get to make this speech that was made to me by Terry Fry, who's been mediating cases probably as long as Joe. And that was back in the mold days, and the plaintiff was, in my opinion, was an absolute crook, had cooked up this whole thing, and my client wanted to pay X number of dollars. And I'm arguing with him. I'm like, dude, this is crazy. Let me go try this case. And Terry Fry took me by the collar and he pulled me out in the hallway. He said, it is not your job to tell the insurance company whether they need to pay money. They're making a business decision, and your job is to let them make that decision and to help them make that decision. And it really resonated with me. And so now every once in a while I get to use that with a young defense lawyer who's trying to show off for the carrier, I wouldn't pay that, that's too big a move, they didn't do this. And I'm like, not your job.
Right.
Not your job to tell your client what to pay to settle this claim because you don't know what all's involved.
Agreed.
And quite often, when it comes down to a battle of the experts, they pretty much just cancel each other out. And so what I see more times than not is when I take a case to mediation, it's really about the claim file and the documentation, especially if a public adjuster was involved, that they did. That's what moves the needle to me. It's not the great legal argument, although I like to think I have some good arguments sometimes on legal positions or policy determination issues, but it's really about the facts. It's about the documentation. It's about can you speak a little bit about comparing estimates that PAs do, and everybody uses Xactimate and other...
Sure.
Contrasting that with maybe a bid or a contractor that the insured has spoken to, somebody that's actually going to go out and get the work done.
Right. Okay, so in terms of what's the anticipation before the moment of mediation commences, right? The insurance company wants to know their file is in perfect order. They demand all these things from you. They make sure that you've satisfied them before they'll set a date. Sometimes we do them in a mass mediation format where, after a great disaster or a hurricane, we'll do 10 in a day, 20 a day. So when that happens, all rules are off. But the typical mediation is they want to have you have their claims file, they have your damage documents, your adjuster, PA estimate, and it's frustrating because when you go to the mediation, they say, well, we've already made our mind up what we're going to pay on this. We'll keep an open mind if you show us something new. So I'd like to just say that is a little trap, in my view. Certainly, you will have done everything to satisfy their discovery needs if you're on the plaintiff's side, on the insured's side, so that you can have, a arm's length willing mediation. But when you are there as the expert or helping your attorney like Mr. Hodge before a mediation, if someone says, well, what else you got? I mean, that's a question I have. Is it good to hold something back? If I were advising someone as a litigation consultant rather than a mediator, because we want to know that we're getting 100% of their value. Before the defense, the insurance policy shows up at the mediation, they have asked their attorney for their evaluation, right? I mean, that's the whole point.
And sometimes they take it and sometimes they ignore it.
Correct.
As we well know.
And what we hope is that the attorney, was wise and didn't try and promise the world, let's manage expectations. Right. Here's what I need to get it settled. Probably you'll give me 75% of it, but then, the defense lawyer can say, I told you so.
Right. And that's an easier phone call.
Correct.
Well, I know I came in with $30,000, that's all we were going to pay, but the defense attorney had asked for $35 or $40, and so turns out they were right. I like those because that's when the phone call gets made.
Mature attorneys will ask for something like that because they're confident in their business stream. Yeah. They don't have to hit a home run every time to try and make a name for themselves.
Well, and you're never going to hit a home run going into mediation. The home runs, to the extent that they happen, which are not very often, happen down at the courthouse. A defense attorney who tells their client, or a plaintiff's attorney, this goes both ways, who tells their client, as I gave you the example earlier, you're going to win this 10 times out of 10, is a fool. because when he doesn't win it 10 times out of 10, you know whose fault it is? It's his and his alone. Nobody else is going to get any criticism except that lawyer. And the experienced lawyers, I had one yesterday, and I said it to the guys in the other room, to the plaintiff's attorney. I said, this case got settled because the defense attorney's been doing this for 30 plus years, and he knew how to evaluate risk and expense, and the carrier came in, they listened to their attorney who said, guys, you've got some risk. Well, what's our risk? Well, we've got an underwriting file that says 3 years ago we walked up on that roof and it was in good condition. And now we say it was you know, it's worn out, it's wear and tear, it's all this kind of stuff. So yeah, looking at that ahead of time, and all defense attorneys go to their clients ahead of mediation. Nobody comes to mediation, as I told you earlier, and decides what they're going to pay. Yeah. What you hope is there's some flexibility when we see something.
That's certain, and I want to give like an example of holding something back. And I don't mean intentionally to hold something back, because you know, if we have a lot of public adjusters here, I mean, you know how to do your job, and you want to do a complete file for your attorney that you're working for. I mean, hold something back, why would I do that, right? But the examples that I remember pulling together that I've seen claimant attorneys do at a mediation, for example, is cedar shake roof, right? Well, that can, you know, we can just do a few squares and replace that. But something came up. It was the homeowners association doesn't allow that anymore. You know, of course, those are really obsolete roofs these days. Another would be, well, we can go to the boneyard and get a few, you know, shingles and make it look right. But again, the homeowners association has a rule and we were able to show it, or the city has an ordinance and it requires, you know, a certain look. So you can't have patchwork roofs. You know, things like that came up at a mediation, and in fact, it made a difference.
Yeah. And again, it's important to know, as the last speaker was talking, you got to know what the policy says. Because generally speaking, in Texas, you don't get matching. Everybody out there that does PA work, you know that. You've heard that a million times. Texas doesn't provide matching. I've taken many cases up to the appellate courts on that very issue. But if it's an ordinance, now maybe we're getting into building code upgrade coverage, so you got to know what that looks like. The number of times that we'll be in a mediation and somebody will be talking about, well, when we take off the mod bit roof, we got to add 2-inch ISO board because that's what the new code says. And I'll say to the plaintiff's attorney, does the policy have code upgrade coverage? That's a good question, Sheryl. Let me look at that. I said, well, it's a $50,000 line item in your estimate, so yeah, I think you'd want to look at that and see if that's a sub-limit, if it's a separate limit, you know, whatever. So, you know, be prepared for that stuff. If that's your estimate, you should be able to justify everything that is lined out there.
When the question gets asked, why is line item 17 in there? You need to have a response.
Exactly.
You got to be able to back everything up.
Especially if line item 17 is $75,000 of a $150,000 estimate. You think, you know, what I see a lot is decking. I mean, a 30 square regular 3-tab shingle roof, but we need, you know, 30 squares of decking. I'll say to the plaintiff's attorney, why do we need decking? Well, I mean, it's part of the roof. I know it's part of the roof. Tell me what the direct physical loss or damage of that decking is. Well, we think it's rotting. I'm like, bad answer. you just, you know, talked yourself out of coverage. So, yeah, that's important. But back to your question, and we kind of skipped around. The direct question was, when you come to mediation, do you just rely on the PA's estimate or the estimate that the lawyer has asked you to prepare for mediation, or do you maybe hold back the fact that you have a real estimate from a contractor who says, I'm going to do this work? I'll do your 30 square roof for $14,000. PA's estimate says $27,000. Now, the plaintiff's attorney may say, I don't want them to know that in the other room. We're early in discovery. We haven't had to produce any of this. I don't want them to know that. I say, great. The reason that is a good idea is because you have a client sitting there who has this expectation that it's going to cost $30,000 to put on just your regular neighborhood roof. And when they know that it's not going to cost that much, that he can actually get a roof done for $15,000, then the case can settle.
Sure. And you just brought a great point that gave me a memory. And it's like when you're defending somebody in criminal court, you know, it's like, please tell me the truth. Tell me all about it. I can't help you unless you tell me the truth. And I sympathize and wonder how many PAs have had somebody not tell them about the prior claim from 5 years ago, you know, and how many PAs have said, well, I wish you had told me that you had been talking to State Farm or whoever before I showed up to help you, and that you had shown them this, you know, $6,000 roof estimate. You know, and I know you have a way to find that out. I mean, it's just communication with your insured, but certainly knowing that, how many times have I mediated a case where the defense insurance company said, well, you know, look at this claim from 5 years ago, and we've got the photos, and they haven't turned them over yet. And I'm like, well, what do you want me to do with that? Are you going to share them or not?
Yeah.
You know, or you can show it to them now, and it's clearly like the same photo. So that's a killer, and that empowers, you know, and makes it harder to settle, obviously.
Yeah.
Can you both speak a little bit about the science and art of mediation? So sometimes it's just about the numbers, but a lot of times with these homeowners, especially if it's a hurricane claim or a tornado claim where they have been out of their house or they're living in their house but they don't have a kitchen, so it has been stressful on them. You know, we know that maybe only 5% of cases are actually going to get tried and go to court. I think it's therapeutic for my clients a lot of times to have their quote-unquote day in court by sitting through the mediation process, because they feel like they can speak directly to the insurance company, let them know how they feel about it, and maybe that $100,000 offer would have been rejected if it was just sent over in writing.
Sure.
Right.
But they're willing to accept the $100,000 after they go through the process of mediation, because they feel like they were able to address their grievance, I can't talk, with the insurance company.
Right.
They were able to sit there and look the
Right.
adjuster in the eye and say, you know, this is what I've been living with for the last 6 months. This is how it's been difficult on my family, and this is how this has impacted me.
I think a lot of times, I find a lot of times, it seems to be more true now that we're doing mediations by Zoom, which I love, by the way. The plaintiff's there, and the plaintiff is very quiet. And the attorney's giving me all the arguments. And then kind of towards the end of the mediation, we're not really at the numbers, and the plaintiff says, you know, Sheryl, here's what's really hard about this. I've been with, you know, USAA, I'm just going to throw that out, because they write military. You know, I've been with USAA, my husband and I have been with USAA for 30 years. We're both disabled veterans. We served in Iraq, and we are now disabled, and they tell their story. I'm looking at that, I'm like, why the hell didn't this come out earlier? Why am I just hearing this now at the end of mediation when the insurance company tells me they're out of money? Right? So I go in the other room and I'm like, guys, you need to hear this. And sometimes they do, and sadly, sometimes they don't. Sometimes they don't. And then the jury gets to hear that.
But that risk-reward analysis where they can make the business decision,
Right.
you have the documentation in the Xactimate, but you got to effectively tell their story also so they really know what that risk-reward analysis is and taking the case to trial.
Well, I like how you said it, the science and the art, because, you know, mediation clearly is, you know, both sides, it's confidential. I mean, these are all facts. These are scientific. You know, it's usually ordered by the court, and, you know, one side pays half and the other side pays half. There's all these, like, sort of boring details about mediation, but the art of it is therapeutic. And, you know, the lawyers know each other, and the PAs have been doing this for a while, but oftentimes the insured has been through a horrid experience, you know, and in a tragedy or a, you know, disaster, it could be out of their house for a long time. I've been through it. You know, Hurricane Ike destroyed my house, about $300,000 claim, and it was mainly flood, okay? But the stress of moving.
But the flood came from the roof leak, right?
Well,
not
yeah,
the
right.
rising one.
Actually,
Okay.
but I did get I was running for statewide office, actually, at the time, and the TWIA adjuster showed up at one of my fundraisers and was going to put my roof check in the little fishbowl, and I was like, no, hand that to me. Don't put that in there. But it was a good adjusted claim. I was very pleased with it. But what I'd say is a lot of people are out of their house. You have to give them an opportunity to be heard. And the PA is often the first line of communication, right? I mean, you know your client, and a lot of times then the attorney comes in second. But if there is a story to tell, then that is something that a jury will hear if it doesn't settle. And you're right, Sheryl. Sometimes the mediator can say, you need to hear this.
Yeah, yeah.
That's the art of it, the listening, purging the story and getting it out, because this may be actually the only hearing they get.
Yeah. And let me speak to that as well. I think some people in the room may be under a little bit of a misconception that when we do these mediations, that we have this big opening statement and there's a PowerPoint and everybody. We almost never do that, because the lawyers and mediators, such as myself and Joe, we know this stuff, right? We know what a box of nails costs. We know what hail damage looks like. We know what wear and tear looks like. We know what the policy exclusions are. And so a lot of times the lawyers, I'll say, does anybody want to make any opening statements? No, I just want to say, thank you for being here, and we're here in good faith, ding. And then we go into private breakout rooms. So the plaintiff is not really getting a chance to hear what the other side says. It is completely up to me to bring in the good news, the bad news, the ugly news, and I know Joe is the same way. I'm not a numbers carrier. There's a lot of mediators out there that will carry numbers. They'll come in, they'll say, well, they've come back at 4,000, but hey, have y'all seen that movie and then they'll chat you up a little bit, and then they'll go back up in the other room and they'll chat them up and they'll get another number. I spend every minute of mediation in the weeds, pushing on both sides.
That's
and sometimes
right.
I have to apologize, mostly to the plaintiff, to say, sir, I know it sounds like I'm beating up on you, but trust me when I say, when I'm in the other room, I'm doing exactly the same thing to them. I am telling them what their risk looks like.
And Sheryl, how well said. I mean, and the other part of this is, I love that song, you can't always get what you want.
I sing that in mediation all the time.
But if you try sometime, you get what you need. It is made for mediation. Mick Jagger, ladies and gentlemen.
Yeah, that's right.
And what I would say is that, look, we want attorney's fees, and we want treble damages, and we want, this, that, and the other. And the truth is, at least the mediator will find out from the PA, look, how much do you really think it's going to cost to get this roof done? And I need to know that. Right. And what is the deductible? And what if I were able to get 75% of that? I mean, if you could walk in and say, look, you've only paid for the mediation. This is really like a pre-suit mediation if it's Texas windstorm, or maybe it's early in the litigation if it's in federal court, because you were saying the judges now, or was it you, Sheryl?
Yeah, so that's a good point, and we're running over time. I was supposed to get us back on schedule,
sorry.
It's okay, I'm doing it. I'm pushing us off
you
schedule.
You got 3 lawyers up here.
I know, we can talk forever. But so kind of the model of mediation was you file a lawsuit, you go take a bunch of discovery, a bunch of depositions, retain experts,
Yep.
and a week before you go down and pick the jury, the judge orders you to go to mediation. And that's the same model, on PI cases and others. But on first-party claims, I think a lot of the judges, especially now we're ending up in federal court more often, are realizing, we have a dispute here, but it's really about dollars and cents.
Right.
They've opened up coverage to some extent. Now, maybe they've only paid $5,000, you say it's $95,000. But there is an insurance policy here. It does provide coverage for it. So it's really a disagreement about amount of money. And more often than not, I have federal judges that are ordering us to go to mediation early in the process. And I find that there's kind of a sweet spot before both sides dig in too much.
I'm doing a lot of pre-suit mediations. I don't know if I've had a lot of carriers that are coming to me pre-suit, which I think is great. And I'm trying to lower my mediation fee to recognize that maybe that's the right time to settle things. The other thing is, just in terms of when claims say on the insurance company's books for too long, that's not a good thing. They want to get them closed, they want to get them settled, they want to get them tried, mostly want to get them settled. They got reinsurance. There's all kinds of things going on in the insurance business world that makes them want to come to mediation, not because they got a terrible case or, they're going to find out, the adjuster did this or that. They want to get these cases off their books. And also remember, they got PPOC, your prompt payment.
Payment Claims Act.
And the longer the case goes on, the bigger that number gets.
That's right.
And that number can become really scary. I mean, that number can almost be as much as the contract damages if you let it go on for 3 or 4 years.
Yeah.
So,
Well, thank you all very, very much. Any questions from the audience? Yep.
No, I see it.
It can be. It can not always. It can be part of the limits. I mean, again, you got to look at the policy. You got to look at the policy. Generally, you're right. 75% of the time, 85% of the time, it is an additional limit. But remember, it's also incurred. So, you know, I always hear that argument. Well, but that has to be incurred. I'm like, dude, we're at mediation.
Yeah, yeah.
Either you pay it now or you pay some compromise on that, or, you know, we're not going to settle this and they're going to come back and try to recover their...
What is or isn't appropriate for the mediator to do in mediation? Meaning, for example, I had a recent mediation where I just felt that the mediator was just, he started off with, well, we've got the insurance carrier saying this much, and we've got the public adjuster's estimate, which we know is full of fluff, which I just thought was a really bad tone to start it. And then he made a comment like, you have this much for the flooring, which is ridiculous. And I just felt that, you know, so like, when is that, or is that not appropriate of the mediator to do?
And some mediators get hired again and some don't, you know, and right. So, I mean,
I would say get with somebody like Sheryl or Joe that knows what they're doing on first-party claims. One, do they even know what a public adjuster is?
right.
Yeah.
What role you're playing?
Yeah. Yeah, they're
Yeah.
different than
Well,
a physician assistant,
So,
right?
so in Florida,
Well, sometimes
Yeah.
a judge will assign a mediator irrespective of their expertise.
Yeah, but I told them earlier, almost always you can file a motion to agree on a mediator.
Sure.
Yeah.
Judges would rather your lawyer agree.
Sheryl, I liked how you brought up the issue of the disabled vets and with that claim, but also be aware when you're bringing a client to mediation, and I'm speaking to the public adjusters mainly, is the insurance company is sizing up your client, and they will jump all over it if they see that your client is someone that can't be controlled, that will make a terrible witness, that will affect things in the future or at the mediation. Make sure you set those expectations with the client before you go. But I had a question for you guys. Are you finding in the first-party property world what's happening in the liability side, which is once a lawsuit is filed, the claim professional is abandoning the file to defense counsel, and defense counsel is spinning things to benefit a lengthy litigation process?
There are a few firms, which shall remain nameless, who we think kind of bilk the file. You know, plaintiff says, let's get to mediation. They're like, well, we got to take some depositions. In first party, remember, your client is the insurance company. And so they're all about, no. I get to say what's done. I mean, I couldn't take a deposition. I couldn't file a motion without getting permission from the insurance company and telling them what that would cost. And again, what's the risk? What's the expense? Why are we going to file this motion? So it's very, very different. In the liability world, when you go into mediation, my understanding is that the lawyer often has no idea what that liability adjuster is going to pay on this. In first party, I told my clients 30 years ago, I said, if you don't tell me what you're going to pay on this, I can't run this mediation to your best interest. I got to know what you think this is worth. Ballpark, 30,000, 60,000? You know, don't keep it a secret from me.
Yeah, and great point. And I did not find that, you know, maybe 5% of the time that somebody's churning the file and has no interest in advising their client to settle. Usually the adjuster's in charge and asking the attorney for advice and really trying to make an effort. I would also say in the Texas windstorm example, you know, the statute now provides for pre-litigation mediation, which it sounds like is happening with outside the TWIA statute.
Right.
So, you know, there's no churning there. The real mistake there is that sometimes it's just a very small, low-ball offer.
Yeah.
And something else, and just one parting thought, I know we're way over, but if nothing else, even if we don't settle the case at mediation, I think it narrows the scope of what we need to focus on in discovery a lot of times. And so it highlights the strengths and the weaknesses, and it's kind of like testing it out before you go try the case.
And I have used that phrase, discovery mediation.
Right.
Like, oh, I didn't know that. And so, Sheryl, I know you're the same way. You'll be like, look, you've paid me, just let me know. There may be like, scene 2 and 3 to this play.
Right,
and,
right.
And
I
you'll
have
stay
a
in.
stack in my office.
Yeah.
It's usually Shannon Lloyd cases. She wouldn't mind me saying that I have to follow up and follow up and follow up. And it actually is based on the law. She files a motion that says cosmetic damage is not this, and then the defense files a motion saying that you only get ACV because you haven't made repairs in 365 days, and they battle each other, and one wins and one loses, and then they come back and they go, okay, now we want to try again.
Yep.
So it's, I say it's, mediation is never over till
Till it's over.
till it's over.
All right. Thank you all very much.
All right.
Thanks.
Thank y'all.